Ladies and gentlemen, our warrior with the powdered wig.
Should be powdered wig.
Yeah.
All right. Sorry about that. I need to have notes now because I'm getting to be old and decrepit here. All right. I didn't get to speak to you in May or June just because of press of business and couldn't make the meetings, although I think I might have been at the June meeting. But in May, we won a very significant case in the Ninth Circuit, Tixeria versus Alameda County. That case is funded by Second Amendment Foundation, so please be sure to thank Mr. Gottlieb. In addition to the Second Amendment Foundation, the case is also funded by Cal-Guns Foundation and the Cal FFL Association. Basically, Tixeria was about 3 men who wanted to open a gun store in Hayward, and or may have been San Leandro. And they complied with state and federal law. They had a lease on a building. It was an old paint shop. It was located in not even in a strip mall, in a little commercial area right next to the 880 freeway. The problem they had was trying to comply with a 500-foot, basically red line rule in Alameda County unincorporated areas that says you can't locate a gun store within 500 feet of everything, okay? Which means if you do the map, there's about 3 places in unincorporated Alameda County where you can put a gun store, and we couldn't get a farmer's permission to do it in the middle of a cornfield. Anyway, we brought the lawsuit, and the only challenge was to the 500-foot rule. So what had happened is my clients had actually gone to the zoning board, which is usually a board of citizens. They aren't professional politicians, and they usually take a look at applications to grant variances or exceptions to the rules. It turns out that they were within, depending upon how you measured, they were within 483 feet of the closest residential property that disqualified them from having a piece opening their store. The only thing was that piece of property was across over a 12-foot cement embankment, over 8 lanes of the 880 freeway, and then back down a 12-foot embankment. And so they successfully made the case, by the way, without a lawyer, that they should be granted an exception because they were, you know, for all intents and purposes, far enough away. And the variance was granted. They were given permission to open their gun store, except that Alameda County has this weird procedure where if a member of the community objects to the variance, the Board of Supervisors has the power to revoke the variance. And so that's what happened. 2 homeowners in some anti-gun supervisor's district complained. They held a meeting, and I think it was a 3-2 vote, said, no, you can't have a gun store because these people just don't like guns in their neighborhood. That was literally the reason they gave. Well, they contacted back to my office, and SAF and Cal-Guns Foundation and Cal FFL gave the green light to go ahead and file the lawsuit. We lost in the district court. We filed an appeal, and we won the appeal 2-1, basically on a straight line rule that says this: gun stores are different from shoe stores and tattoo parlors and you know, bread stores. Okay, we provide people access. Gun stores provide people access to exercising a fundamental right. They're like a bookstore or a church. They're more like a bookstore and a church than, say, a shoe store or a 7-Eleven. And therefore, because we provide people access to a fundamental right, the government has the burden of proving that their rules somehow enhance public safety. And our argument was we didn't get to do, the county wasn't put to their proof in the trial court. And therefore, the case should be sent back to the trial court with instructions for the county to put on evidence, real evidence that we'll get to challenge in the trial, that this 500-foot rule actually helps enhance public safety. We don't think they can do that, so we think the case is a winner when we go back to the trial court. The status of Dixaria is the county is asking for en banc review because, hey, why not? It's a gun case, right? So we're still stuck in the Ninth Circuit while the entire court tries to take a look at whether or not they should overturn this 3-judge panel, which takes me to another case that I can report on, and that is the Peruta and Richards case, the CCW case that was overturned by en banc review in early June. So we had the win in Dixaria in May, and then the loss on concealed carry in June. I don't have any explanation for what happened. We won that case fair and square before the 3-judge panel, and then there was some changing of the guard in the Ninth Circuit. En banc review was granted. There was a motion by the Attorney General's office of the state of California to intervene in the case at a very, very late stage, very unusual occurrence. In any case, the 11-judge panel reversed the 3-judge panel, and as of today, the right to keep it, or at least the right to bear arms in California, is stuck in the bad old times, and you have to show good cause to a sheriff. Currently pending, and again, this is somewhat of a Hail Mary pass. Currently pending is a request for full court en banc. Now that procedure comes about because the Ninth Circuit is so large, there are actually 26 active judges in this circuit, that when the court sits en banc, and en banc means entire court, when the court sits en banc, they really only pick 11 judges, the chief judge and 10 randomly chosen judges. The rules, the federal rules of appellate procedure and the circuit rules of the Ninth Circuit provide for a procedure. It's very, very rare where the entire court, all 26 judges, can rehear the case. So earlier this month, a petition was filed by the Peruta team and by the Richards versus Yolo team, and again, Alan Gura is doing all the heavy lifting on that. I just get to hold his jacket while we're in court. And he wrote a beautiful brief saying, look, this en banc panel got it wrong, and here's why. So stay tuned. Peruta's not over, but not looking good.
What was the vote on the 11th?
It was 7-4. There is another case that I'm working on. Again, it doesn't have any direct application here in California, but Second Amendment Foundation has asked me to assist in a case out of the state of Washington. You might remember there was an initiative sponsored by Mr. Bloomberg up there to impose some of the same silly rules up in the state of Washington that have absolutely no effect on crime in California, but hey, why not? He's got money, so let's try and pass some of these stupid rules up in Washington. It's basically a rule that requires, the use of a dealer for, even innocent temporary transfer of firearms. And so there's a great legal team up in Washington whose name escapes me right now, but I'm sure Alan can tell you who they are. And they've asked me to assist them in this. And again, I'm kind of just holding their jackets for them and helping them with punctuation. The Sylvester case is still pending. It was argued back in early spring. Sylvester case is a case that we won in Fresno County, and it eliminates the 10-day waiting period for people who have concealed carry permits, COEs, or whom the state can determine already has a firearm in the AFS system. The idea being is that the 10-day waiting period is redundant if you already own a firearm and you've already passed a background check. look for a decision on Sylvester probably before the end of the year. One case that Second Amendment Foundation is the only organization funding this case is a case that's right here in San Jose. It's a federal court. It's Rodriguez versus the city of San Jose. This is a case in which a woman who owns her own firearms and also has a community property interest in the family firearms is being denied the return of her firearms even though she has a California-approved gun safe and she is not a prohibited person, and at least 3 of the firearms are her personal property because she lives with somebody who's prohibited. And her position on the case is that if the state of California is going to impose a requirement for gun safes and safe storage and say that that is the device for denying people unauthorized access to guns, that you cannot deprive a law-abiding citizen from having the right to keep and bear arms in their own home if they live with somebody who is also prohibited. Very important case.
Quick question on that.
I'll take questions after we issue our report here. Let's see. I'm not going to fill you in on the bad news with regard to the legislation. It's really, really bad. Before you ask, yes, we are looking at ways to challenge these laws, but right now, when Antonin Scalia died in February of this year, I have a sneaking suspicion that there were some people who celebrated and it wasn't awake. All right? And right now they're basically dancing on his grave and daring us to file new cases because they know that at best they'll get a 4-4 tie if his seat remains vacant. At worst, Hillary will judge and they'll work their hardest to overturn Heller and McDonald. I'm not going to get into election politics at this particular point in time. I'm the wrong person to ask. The only advice I can give is the advice that my candidate, who did not make it, Ted Cruz gave, and that is vote your conscience. All right? One thing that has happened, and I have harped on this every time I speak, the volume and the turnover of criminal cases that are coming into my office is increasing. They are for more and more chicken shit violations, and they are not friendly when they come to your door. This is not some, undercover officer in a suit and a badge and saying, hey, we'd like to talk to you about, some of your firearms transactions. They drive up into your front lawn with Suburbans with blacked out windows, special agents in full SWAT gear, and I'm waiting for them to start shooting the family dog, okay?
Wow. 9
times out of 10, they don't have a warrant. And the reason for that is their own records are so crappy they probably can't get a warrant. But they talk their way into your house, they talk their way into your gun safe, and you convict yourself when you cooperate. If you don't exercise them, they're not rights. I don't know how many times I have to say this, or how many times the word has to go out. When the police show up and they give you that big toothy grin and say, look, this will go better for you if you just cooperate, your response is, thank you very much. Don't use 4-letter words. Don't cuss them out. I'm a professional. I can do that. Okay? I know where the line is. You don't. Just be polite, okay, and say, officer, if you don't have a warrant, I think we're done. And he'll come back with, well, we'll get a warrant. I said, well, then come back when you get one, okay? If they do not have a warrant, you ask them to politely leave. They don't have the authority to stay on your property and keep hassling you unless they have evidence of a crime, and if they had evidence of a crime, they'd have a warrant. So you ask them to politely leave, and you do not consent to a search of yourself or your vehicle. If you're out on the road and you're transporting a firearm, make sure you're doing it so legally. Unloaded in a locked container, If it's a handgun, you better be traveling between two places that you're allowed to have the gun. Well, review California law. Just the same, if you are on your way to the range, or you are coming out of the field from a hunting trip, and the officer says, you know, if he sees the weapon, there's some statutory authority for him to inspect the weapon to see whether it's loaded or not, okay? I maintain that he doesn't have that right, but that's a legal issue, and you can't have that fight with the officer out in the field. Nevertheless, if he asks to inspect your weapon, you say, I object, I do not consent, but I'm not gonna stand in your way, officer. And then he'll go into your vehicle and he'll look and he'll do whatever it is he's gonna do. But you make it clear that you are not consenting to a search. All right? Not only is it a good idea to have a phone number of a lawyer in your wallet, you better have the phone number of a bail bondsman in your wallet.
1-800-GET-OUT.
All right.
Mama wants you home.
Is that the time?
That's all I got. I don't want to take up I'm going to take 3 questions.
Great question.
Okay? And then I'm done because we got to get on with this evening. I'll start to my right. 1, 2, 3. That's it. That's all for tonight. Yes?
Is there some point in that conversation where you turn your cell phone camera on or audio recording device? Or is that escalating?
What was the question?
The question was, at what point do you turn on your cell phone camera? You know, it's not illegal. It's, you know, the issue is whether recording somebody without their permission in California has to do with a reasonable expectation of privacy. If you're in public, neither of you has a reasonable expectation of privacy.
It's not over a wire, so.
You cannot interfere with the officer doing his job, okay? The officer has no reasonable expectation of privacy in your home. So, video surveillance system, yeah. Security for that, so that people can't tap into your Wi-Fi and look inside your house, probably a good idea, but not a bad idea to have video surveillance. That's a judgment call. I'm probably not inclined to turn on a camera, but you know, I don't dissuade people from doing it.
Your objections are moot at that point because there's no record of it.
No, that's not true. No, in a court of law, the burden is on the government to prove that they had consent, if consent is required. So they have to get up and lie, and you know they might. Okay. Yeah, you know what? Dash cam might do the trick. I don't know. They're about $150 now. Okay. There was another question here. Three, and if Mike's invoking a special point of privilege, I'll let him ask a question. Yes, sir.
So you were discussing Sylvester and approved safes to protect firearms from prohibited persons. And I'm just wondering if you believe there might be any bleed over into having children in a home, because California law says you have to have an approved safe if you have children in the home. And for foster parents and other folks, it's very clear you have to have a gun safe because they're prohibited under that. So if the prohibited persons statute doesn't apply, is there anything out of Sylvester that could hamper parents? Or can you use that argument to drive away? I'm just concerned that it becomes really gray.
Well, the law in California now is, the safe storage statute is that it is and they just make this stuff up, by the way. It's the third, California doesn't have degrees in misdemeanor, by the way, but they made this up for this statute. It's a 3rd-degree misdemeanor if you have a handgun and a child can get to it. So it doesn't matter who the child is or anything like that. Now, it's a more serious crime if the child gains access to the gun and hurts somebody, or death or great bodily injury, you can be charged, okay? But there is a statute on the books in California that says the negligent storage of a firearm, you know, with a child in the house is a class 3, whatever the hell that is, class 3 misdemeanor in California. Sylvester doesn't help on that at all. This is one of those areas of law where I disagree with the law, but I agree with the policy. When people come to me and ask me common sense questions about firearm ownership, and they say, you know, I really can't afford a gun and a safe. And I say, well, then go without the gun and get the safe first, okay? There's no reason not to have a safe if you're going to own firearms, okay? That's just, you have to do that. Mike, you got a point of special privilege, and then I got to turn it over.
Just real quick, in California, for them to charge you for the rights of engagement, does the gun also be loaded? Or it's unloaded, then you're okay?
I'd have to look at the statute, but I think you may be right.
I think it has to be loaded.
You may be right, yeah. Mike?
With the legislation that got signed about the firearms that were previously legal with a bullet button, they're now, as I understand, assault weapons. Is registration going to be open, or is if you have possession of one of those, too bad, you can't have it, you got to get rid of it?
Well, I mean, who knows? I mean, I just argued a case last week, Haney versus Harris, where the sole issue was the fact that the Attorney General of this state refuses to issue guidelines and bulletins and industry circulars to help define assault weapons, and people are getting falsely arrested for possession of assault weapons. So nobody knows. Now, we can sit here and speculate that it should be open registration at this point, and basically that if you go ahead and register your bullet button off-list lower AR, you should be able to take the bullet button off, right? Okay, but be careful that you don't plug in a larger than a 10-round magazine, okay? These laws are insane. There's just no other way to describe them, but they're insane.
Is that going to affect them?
No, it does not. The law takes effect January 1, 2017. The registration period closes, I think, January 1, 2018. Yeah, and by the way, there's already a new device out that there's a quick disconnect on the rear pin on AR, and you can drop the magazine. So they've gone from you can't have a high-capacity magazine to you can't have a high-capacity magazine unless it takes a tool to remove it. Now you can't have a detachable magazine, not high-capacity, detachable magazine, unless you partially disassemble the gun. Now the next rule is, unless you're wearing a pair of Mickey Mouse ears. Okay? This is how absurd these laws are getting, because, look, you know, the problem is that the smartest mouses are in Silicon Valley, not in Sacramento. And the dumb shits who are writing our laws can't outthink the engineers and figure out ways around this stuff. I hope to have a better update for you on how to comply with the legislation that was just passed. Maybe we can do that do we have a meeting in December?
No.
October is our last one for the year. November.
November is your meeting.
Well, we'll just do a quick how to comply.
Oh no, I want you there for full hour.
I have to clear this with the Admiral. You know who the Admiral is, right?
You can also teach us how to cuss and legal phrase up in Latin. How about that?
Yeah, all right. If I'm free, I'm here. If not, I'll send an outline.
All in favor of the Donald November, say aye.
All in favor of the Donald?
Thank you very much, sir. Once again, Don Kilmer. I'm sorry?
About Donald.
The Don. The net R Don. Okay.